Okay, here's the question. What questions and expectations can an employer ask of a pregnant employee who has commented to their supervisor that they won't be returning once they have the baby? Do you want me to just keep it at that, or do you want me to read the rest, the specifics?
I think that's enough to get us going,
Okay.
you know.
So the employee has made a comment to their supervisor that they're not returning back to the office after they have their employee.
Right. And and look, it's a tricky situation, right? Because you're talking about, depending on the size of the company, and where you're at, you're talking about, an individual who, under the FMLA, they may have, the right to unpaid leave for 12 weeks, whatever other state law benefits may be out there. And their condition, pregnancy is protected under state and federal law and in most states, including Illinois. And so, it raises this question of, well, what can we talk about, right? How much can we get into with this employee without running into a problem, right? Is this like, somebody just celebrated a birthday that's, over 60, would you corner that person and say, when are you planning on retiring? No, of course not, right? But here it's a little different in that, the employee has said they're not planning on returning. And that sounds to me like a resignation. I don't know. What do you think about that, Jolie?
I agree. I do think that implicates or gives the implication that the employee is looking to resign. However, before processing a resignation under these circumstances, you want to consider a few things, such as, does the employee qualify for FMLA leave? And if the employee does qualify for FMLA leave, really the qualifications are, did the employee work 1,250 hours for the year? Is the employer 50 or more employees in that jurisdiction within 75-mile radius of the employee's work site? And provided that those qualifications are met, the FMLA does protect or could protect that employee depending on the circumstances. So with that, there are certain requirements that employers have to keep in mind to comply with the FMLA, such as providing certain notices like an eligibility notice or a rights and responsibilities notice, a designation notice. These are all required under the FMLA. The failure to provide these notices could run afoul of the FMLA and give rise to liability. So these are things to consider prior to processing a resignation, processing a termination, just to see if this employee does have alternative protections under the law.
Right. I mean, it's definitely something you want to document, because you don't want to be in a position, a year from now saying, no, we didn't give the FMLA notice because verbally she said to the supervisor, well, I'm not going to come back. Right. You want to have documentation in place showing that the employee is not coming back, because if the employee is not coming back, that's not protected by the FMLA. And if the employee took FMLA and didn't come back, potentially the employee is creating liability for themselves under the FMLA, because you're supposed to have an intention of coming back when you're asking for FMLA leave. And so, the fact that they volunteered this information makes it fair game to talk about. And I would certainly think about, also, why is the employee already saying they're not coming back? And, is that enough to, raise a concern about, did they feel mistreated? Are they going to claim that this was a constructive discharge? Is there something more underneath this that, HR needs to investigate, before this person's gone, they're not going to come back, and then, has plenty of time to talk to a plaintiff's lawyer about their situation. And if it really is something where the employee is just saying, look, I've got that, I've got other things I want to do, great, get that documented. If it's an issue of, I think something unfair is going to happen to me when I come back, find out what that is so that you can still do the investigation that you might, be charged with needing to do.
Great points, Pete. And, to piggyback onto that, the goal is to mitigate risk all around. So in doing so, one of the things to also consider is, is this employee someone who has had performance issues? Is their personnel file documented with performance issues? Because, if push comes to shove, that is always the best fallback for employers to say that, hey, this person wasn't meeting legitimate performance expectations, so we were justified in the actions that we took. So we want to make sure that we can have proof of that if faced with potential litigation. It's a much more defensible case if there's documentation in a personnel file relating to an employee's performance issues than it would be in the alternative.
Right. Because look, if the employee's going to leave and they're going to leave, but they're going to leave on bad terms, and they may, and you may get a demand letter later, you're allowed to have a discussion with the employee once they volunteer the information. And if you're able to suss out the fact that, hey, they're leaving and might sue you later, you may be able to talk to your lawyer about, coming up with some kind of separation terms. And coming up with some kind of an agreed upon, severance and release agreement and that kind of thing. So, get the facts and definitely talk to your lawyers about, what's being said.
Okay, do you want to move on to the next one?
Yeah.
Sure.
And I have, then we'll tackle the Q&A box.
Yep.
Okay.
Keep them coming, folks. We see 3 questions in there. Keep them coming.
I'm sure they will. And I have some other ones that are not a priority if we need some more, but.
All right. If I start telling jokes to kill time, you guys are not going to be happy.
Yeah, don't let him do that. Okay, this says, I own a house cleaning company and my employees are paid commission by the job and drive their own cars to get supplies at the office and between jobs. They're not paid for this time since it is a commission paid position. Am I fine doing this?
Yeah, this is a good question because it actually raises a couple different issues, depending on where you are. Presumably, the setup here is what's called the retail sales exemption under the Fair Labor Standards Act, which has been imported into Illinois law and presumably the laws of other states. And retail sales exemption, what it talks about is that if you're providing services directly to consumers like homeowners, where you're going in and cleaning their houses, you can pay on commission so long as the rate is 1.5 times the minimum wage. Now, so you want to keep track of those hours carefully because under the Portal to Portal Act, you get paid from your first stop through your last stop before you go home. So the hours that are in between, house number 1 and whatever the last one is, those could be compensable hours depending on what the employee is doing. If they're coming back to your site and picking up stuff, those would all fall into what's called all in a day's work. And those hours would matter when you're trying to compare what the commissions are against the hours to make sure that you're keeping the employees above the 1.5 times minimum wage threshold that exists under federal law. And there's another issue that I can jump to on that, unless Jolie's got something.
I do have something tickling in my mind that I want to address here and piggyback off of what you said. So perfect answer, Pete, but there's a couple of things to also consider. So this question doesn't specify whether or not this person, this worker, is classified as an employee, whether non-exempt or exempt under the FLSA, or whether they're classified as an independent contractor. One of the things to consider with classifications as an independent contractor is how much control does the employer have over the employee. And I know that the question did pose a factual scenario where the where the worker would come to the work site and collect supplies. You know, it's one of those things where if the worker is not supplying their own supplies, supplying their own tools necessary to do the job, then it does create that gray area. It moves more into the realm of, is this person an employee? And really the general rule of thumb is that employees is the rule of thumb. So independent contractors are the exception. So just because someone's paid on commissions doesn't mean that they're properly classified. So we want to make sure that that is step one that is taken care of first.
Yeah, absolutely. And I think the last thing to keep in mind is the mileage. Because, you know, in Illinois, employees, are protected by a business expense statute, where it's actually a violation of our wage payment laws to not cover ordinary business expenses for employees. And, depending on where these employees are coming, assuming they're employees, as Jolie, rightly points out, depending on where they're at in terms of their weekly wage and how close you are to, that 1.5 times minimum wage threshold, those business expenses could become an issue. And I was talking about this a little bit before we jumped on. There were a series of cases. There was a firm out of Kansas City made a fortune off of this. They went after pizza delivery, or they went in on behalf of pizza delivery drivers and went after big franchise groups and big organizations. And what they were saying is that the mileage expense needed to be paid at the IRS rate of 55 cents a mile, 60 cents a mile, depending on, what's happening with the price of gasoline. And the employees in a lot of these cases were getting, $1 or $2 per delivery, which was working out to about 10, maybe 20 cents a mile. And that, 30, 40 cents a mile margin was arguably taking the employees below minimum wage. And that was creating a problem and the basis for a bunch of lawsuits that were filed. And so my point here is that, if these commissions are running you very close to that 1.5 times minimum wage threshold, you may want to look at, mileage expenses and other expenses to make sure that, somebody doesn't read about those pizza delivery driver cases and think, what, I might be able to, go after you for that as well. In Illinois, the way we would cover it would be offering some kind of stipend to cover expenses, and then have a policy that says if you're exceeding the stipend, you can submit for reimbursement. And we'd have to submit receipts, and there'd be a deadline to do it. And you get some pretty good protection under our statute for these kinds of things. I don't know necessarily how all the states would cover it, but do think about, how much these folks are making in relation to minimum wage. And is there enough cushion where if they were saying, that they've got unreimbursed expenses for mileage or cleaning costs or supplies or anything else that they're doing, that you're not blowing the exemption by having somebody being brought down below minimum wage. I mean, these expense issues, they'll get you in California. And, a lot of states are pushing that business expense issue. So another thing to keep in mind.
Awesome. Do you want to, there was a second part to this question. I don't think we can answer, but I just want to let her know. The question was, I verify that they have their own auto insurance. If they were in an accident, could I be held liable? Peter just made a note that we can't answer that, right?
Yeah, I
And-
mean, it gets a little bit, we're not really liability folks. I mean, I will tell you, I got into a car accident, on my way to court one day. And when I called my insurance carrier, they said, hang up, take this one to HR, because it's not your insurance. You shouldn't be the one paying. It shouldn't affect your rate. These drivers are out there on your behalf, and they may be your employees, they may be acting under your direction and control, and maybe, able to create liability for you, as your driver, just like, if I were driving, a logoed vehicle for a company and I got into a car accident, somebody's going to think about trying to take it back to the employer, because it's always going to be the deeper pocket. So I would definitely talk to your brokers about that issue and get, some competent advice as to how to handle that coverage question.
Cool. Just wanted to address it real quick.
Yeah, no, well, it's fine. It reminded me of me getting into a car accident. So I'm delighted to be there.
Sorry. Not a
It
good
wasn't
thought.
my fault. I was totally paying attention. I wasn't speeding, trying to make it to court, honest.
No, not at all.
Right.
Okay, so we have some really good questions here in the Q&A box. I will leave it up to you to answer or questions, to choose which questions you want to do first, or do you want me to just go
Sure.
next?
Yeah, no, I can definitely ferret out some of these questions, and then Amy, feel free to jump in, if there's something pressing, particular individuals that we want to cue in on. So, there's definitely some interesting questions. First off, thank you everyone for participating and logging your questions in the Q&A box. So Pete, I've got a doozy of a question for you.
Oh,
so, maybe this one will stump you. So this one reads, from a legal perspective, how much action can be taken against an employee who has inappropriate stickers on their car that they drive every day to work and park in the company parking lot? Customers and other employees walk past these and see them. Some have reported feeling uncomfortable. These car stickers rang from swear words, political stances, and even silhouettes of naked women. Can a company force an employee to remove any of these from their employees' cars? I assume no, and we have not forced employees to, but curious on another perspective.
You would, yeah, you're right. This is a doozy. So, it's it's a good one, because, oftentimes, if you own the parking lot, you are bringing they are bringing materials onto your property. And that's, I think, your inclination of, yeah, you probably really can't do anything is the right one, because it's their vehicle, depending on the state in Illinois, issues of their political affiliation and having engaged in lawful activity outside of work, can create issues in the workplace, in terms of, what can people say, what can people not say, and it is definitely a delicate one here. If it's your property and, it's hurting your business and you're having, serious problems, you certainly, I can't think of any reason why, somebody's entitled to come onto your property with offensive statements and offensive, materials. I mean, we're not, it doesn't sound like we're getting into, National Labor Relations Act type issues, where, if it's a pro-union sticker, yeah, I'd be a little bit worried about that one too, right? And, if it's truly causing a business issue, I'm not sure that you necessarily have to take it. I don't, what do you think about it, Jolie?
Yeah, so I do have some thoughts to discuss on this one. So the first thing to really consider is what is the type of content that is being displayed in this employee's car or vehicle? Because, for example, political stances, swear words, things of that nature are not really protected under any law that I'm aware of, unless the employer is a governmental employer, then maybe the employee would have First Amendment rights. But aside from that, one of the things to consider is, okay, what are we actually dealing with? What is the content, the messages that are being displayed on this employee's car? Because, there are laws really at the state level for weapons. You have to provide proper notices on your company premises, including the parking lot, prohibiting employees from bringing weapons onto the property. There's cannabis laws, which talk about, can an employee keep cannabis in their car? So you really have to think about what are we really talking about. So once we assess that in this particular scenario, like Pete said, I don't really think that there's anything that would prohibit an employer from at least having the conversation with the employee that, hey, we have a legitimate business expectation of you, performance expectation of you to comport yourself in accordance with our company policies, in accordance with our best practices as an organization, to be respectful and to, have a face to the community that is respectful. So I would think that, disciplining or at least having that conversation with the employee would not run afoul of any law that I'm aware of.
Yeah, I mean, I would just be concerned about the policing issue of it, right? You give somebody, you give an employee a warning, right? And then, if your lot's open to the public, they're going to have their buddies, put some kind of, even more offensive stickers on the car and have them drive in and park. And then if you don't tow those cars or you don't do anything about it, they're going to try to come up with a way of saying that they've been singled out.
Right.
And it could get messy fast. And I'd be a little bit concerned about that as well. But if it's not, if it's not too much of a walk for them to park on the street so that it's less likely that it's associated with you, I'd at least think about it. But it's a tough one because I think if there's one sticker on the car that's, pro-union, then bam, the National Labor Relations Board is going to get a call. If there's something on there that's political and they're going to say they're being singled out for the political affiliation, you might run into that into that type of issue in Illinois about not being able to ask about that. And then, it's definitely one of those of, the unintended consequences if somebody tries to rile up, their buddies to try to, bring a bunch of cars with even more offensive stuff on there. And then to try to say that they're being singled out for unlawful reasons, could be a problem. I think your initial inclination of let it go makes a lot of sense the more we talk.
Mm-hmm. Mm-hmm. All right, so the next question that I think is appropriate to tackle at this juncture reads, is there a general rule of thumb we can safely apply to most HR records as far as retention? Pete, you want to take that one? Or you want
No, it's about records retention. Come on, guys. Like, we're going to lose half the audience. We're talking records retention. So
it's a hot button topic, Pete. I don't know what you're talking about. It's a hot button
topic. Everybody loves it. No, yeah, no, I've had to do records retention plans, so that's why I'm laughing. So you definitely, there are statutes that apply, state and federal. And some of it also depends on, if you're a government contractor in terms of how long you need to retain the records. But, generally speaking, you ought to be hanging on to job applications for, I believe it's a federal one, of at least a year under some federal statutes. If you reject the applicant, if you don't, if you do hire, you're going to want to hang on to that. There are specific record keeping requirements for things like the I-9 that I'm going to confess I don't recall off the top of my head. Payroll records, definitely have to be maintained. You've got an obligation to prove up that you paid people correctly. And so you're going to want to hang on to something to show that people were paid correctly for, at least 3 years under federal law, because that would be the look back on a wage and hour claim. If there's certain kinds of medical records or exposure records, if you're in, the type of business where somebody's, being exposed to chemicals or other kinds of contaminants in the workplace, noise, that could be a 30-year hang on to kind of thing under the Occupational Safety and Health Act. So that's why this is a tough one, and why I was complaining is that, it's tricky, because certain types of records are going to have different kinds of retention times than other types of records. And you need to know how long, somebody can sue you for particular kinds of things before you start chucking stuff. Because, if, under Section 1981, which is a federal statute that protects, against race-related biased employment decisions, that's a 4-year statute of limitations. And so, if you let somebody go and then get rid of all of their disciplinary records and basis for the termination 2 years out, they've got 2 years where they could claim a violation of Section 1981, and you're naked. So I like 4 years on a lot of, things as a general catch-all. But, it requires, a kind of a detailed look at the different categories, because you can always run into, some pretty picayune, distinctions.
To piggyback onto that too, Pete, we're talking generalities here, but the 4-year retention, just general rule of thumb, is really a good pointer, especially because a lot of times litigation issues do arise between employers and employees. And if a lawsuit does come to pass at some point in time, an employer would get what's called a litigation hold letter, which would require the employer to preserve all records relating to that employee that has any relevance to the basis of the claims that the employee has asserted. So, if you keep everything, you're more likely to have everything in the event that a lawsuit arises.
True, but it gets expensive and it gets cumbersome. I've been at this long enough to remember, backup tapes and spools of backup tapes that were being carted out to Iron Mountain and being held on, 30-day retentions, and then having to restore backup tapes and stuff like that. And it was brutal. Now, with the cloud, but you still can run into that problem of, you're hanging on too much and then you can't find anything, and then you don't know what you have, and then you get surprised by it. But so, depending on the size of your organization, having, a well thought out, reviewed by an attorney, retention plan, can be good, so that, you're not paying, a lot of expenses on record retention and, data backup and stuff like that. I mean, it's a two-edged sword. But definitely, if you've got a notice of a suit, yeah, Jolie's right. You can't start, that's not the time to bust out the shredder.
Exactly. That would be the most inopportune time to bust out the shredder.
Right. 'Cause,
Yes.
I'll date myself by making an Ollie North joke if you want, Fawn Hall. Not the time for that though.
Yeah, no, not the time for that, Pete.
Right.
Hold back a little. No, I'm kidding.
Yeah. What else we got? These are good.
Yes, thank
These
you,
are good.
everyone.
I hope everybody's having as much fun as I am. These are good. This reminds me. I mean, when I got my start, I was doing like HR hotline stuff and just picking up the phone and having to answer, just whatever came across the deck that day.
Yeah, it's just making me realize that I would never want to be in charge of employees. So
yeah, no, this is good
it's
stuff.
so hard. There's so many issues that, potential issues.
Right.
Exactly.
This going back to work after COVID is a really interesting one. And I know a lot of our people have voiced the same concern. Can we get to that one real quick?
Absolutely. You
COVID.
read my mind, Amy, because that was going to be the next one.
Oh no, COVID. Come on.
All right.
Why are people still thinking about COVID? The pandemic.
I know COVID is the gift that keeps on giving.
Okay.
All right. So this question reads, can you discuss any legal implications of calling employees back into the office after they've established they can successfully work remotely through COVID?
Yes, we can. Where to begin?
There's a number of them.
Yeah, no, I mean, this is really, this is a great question because it really is an issue that I think a lot of employers are going to have to grapple with, which is, we now, many organizations have, for purposes of the Americans with Disabilities Act and reasonable accommodations, and policies similar to that, have shown that this knee-jerk feeling that we used to have in what I affectionately now refer to as the before times of 2018, where we used to say, well, you can't monitor the employee, you can't give them feedback, you don't really know what they're doing, and you're not going to be able to mentor them properly, and things like that. So it's got to be an undue hardship to let somebody work from home. Well, no, I mean, a lot of organizations, clearly have, the lights have stayed on. The business has continued, work is getting done. People are being successful in what they're doing. It's been a good thing for a lot of people to have that kind of flexibility. And, it definitely has created, a change in thinking that employers should anticipate if you are getting requests for work from home for reasons that may be protected, by statutes like the Americans with Disabilities Act. And, I don't think my expectation here is that, you're going to run into issues if you continue to try to maintain, this position of, it's a hardship to have somebody working from home. And, you may have gotten the benefit of the doubt 3 years ago, 4 years ago on that, but I don't think you will in the same way anymore. And I would, I think a lot of employers are going to have to be, seriously rethinking, their position on insisting that everybody come into work. I mean, I'm here. I'm in the office. You can't tell because I covered the background up, but it doesn't mean everybody else has to be here. I don't know. What do you think, Jolie?
I think you're right on point, Pete. I think issues that would have been able to be relied on in the past, like it's business necessity. You need someone in the office 24/7. I think the way of the world right now has proven that that's not really the case anymore. And, one of the things, it doesn't take away from the fact that employers can require employees to come back into the office. Whether that's going to actually come to fruition or not is another story in actuality. But say for like religious discrimination or religious accommodation, like people who don't want to take the vaccine because of their religious beliefs, sincerely held religious beliefs, or people who are scared to come into the office and be around other people because they have some sort of disability that would make them more susceptible to some adverse reaction if they contract COVID. Say for those scenarios, yes, an employer can manage its business however it deems appropriate. But I think the general rule of thumb and best practice would probably suggest to be flexible. Have the conversation with employees, keep an open line of communication to see what the temperature is for, can this even happen? Because, once you get disgruntled employees, you get more of a opening for risk exposure.
Yeah, and I would certainly look at factors like, these issues of, data security, and, performance metrics and things. If you're going to start down the path of saying everybody's got to be coming in, because I think it does make a difference. If you're talking about, somebody who's got, highly confidential, serious, trade secret, keys to the kingdom type materials, and they're saying that they want to work at home on, a semi-secured, home network where maybe there's a password on the Wi-Fi, and, and they've got other kids jumping into it, versus, different kinds of jobs. Because, those factors would certainly make a difference if, you're looking at the burdensomeness of the situation. If you need people to be coming in for coaching, you want to look at their performance and see if there are objective metrics that you can point to, in terms of, sales performance, productivity, things like that. If you can start to pinpoint some of these things, you're going to be on better standing in trying to make the argument for somebody who just needs to get in, so that we can, get them inside of our network, get them inside of our facility to monitor what's going on a little bit more closely.
All right. Next question. So the next question reads, how do you address an employee that is expounding on his or her religious beliefs to customers during business hours? Pete, want to try your hand at that one?
No. Come on. These are tough. Tough. What happened to, hey, Pete, what's the current minimum wage? Come on. Amy,
you did challenge the audience to stump you, and they did a good job.
They are doing a good job.
You guys are awesome.
These are tough, man. Come on.
Yeah, and we understand that, as employers, you face these tough issues. So, any insights that we can help you along in your business, that, that's what we're here for. So Thank you for the questions.
No, I mean, look, I think that, as an employer, if what you're talking about is a discussion with the customer and the personal opinions that are being offered, religious, non-religious, are turning off customers and creating problems, you do have the right to caution, the employee, to say, look, the customer's not here, for, this kind of conversation. They're here for business related reasons. You're supposed to service the customer, upsell, talk about, whatever needs to be done. And, these side conversations can be distracting. I mean, look, it can be tough, when you're talking about, religious comments. And that, which is why I was dancing around in my chair and feeling uncomfortable, because, there have been suits that have been brought where, the employee's signature line was "Have a blessed day." And the employer said, that has too strong a religious overtone, and everybody else signs everything "Very truly yours." And we want, the employee to change. And, and the employee said, well, it was a sincerely held religious belief, that led me to do this. And, the EEOC took it and it created a dispute. I don't remember who won that one. I just remember reading about it and thinking, oh yeah, this is good. So, you do need to tread cautiously here. I mean, if it's religious, and we're talking about federal law, and they're saying, that they have a sincerely held religious belief that, these discussions need to happen because, that is part, of a sincerely held belief. The undue burden standard that applies under federal law is pretty low. And, if you're talking about, lost customer complaint, customer walking out before a deal gets done, and that kind of thing, I would hope you're above, what, the EEOC or a judge would call an undue burden under those circumstances, because, these kinds of discussions are a two-way street. And, when you're running a business, I mean, the customer is always right. And so, I would tread cautiously with it, but I think, generally speaking, if you've got an example of the customer saying, I don't want to do business with you anymore because your employee made me uncomfortable, that's a pretty good basis to be trying to act upon.
To expound upon that too, Pete. So, provided that this situation, like let's say an employee is disciplined or terminated because they, had these religious conversations with the customers. One, I wouldn't make that the reason. I wouldn't suggest that should be the reason why an employee should be terminated. Because one of the things with religious discrimination suits, there's 4 elements, but the element I want to focus in on is legitimate performance expectations. So as an employee, when they file a lawsuit for religious discrimination, they have to show they were meeting their employer's legitimate expectations. And one of those expectations could involve not turning customers away, not losing business. So we want to make sure that we're documenting the fact that customers are being turned away, that we're documenting that customers, there's a loss of business, regardless of how that loss of business came about, whether it was because the employee was talking about their religious beliefs or not, that their religious beliefs should not be the basis for the disciplinary action or for the documented performance issues. Really hone in on what is the actual impact to the employer. And if that impact is the loss of business, that's what should be fallen back on, and not this nebulous concept that, we just don't like the person talking about their religion with people.
Right. And again, it can create across the board type issues that you want to watch out for, because if this is the same business where they have the car out in the parking lot with the the silhouette of a naked woman sticker on the car and all kinds of obscenities, and that car's still sitting out there, and the employee who's making religious comments is the one that's getting disciplined, and nobody's saying anything about the car with the F-bomb plastered across the side, it's going to make it tougher for you to establish that it was a neutral decision. If you have customers complaining about offensive jokes or random anecdotes or a bunch of dad jokes from somebody who's calling who's dealing with people, and the only one who's being singled out is the person who made the religious comments, you're going to run into a problem there as well. And so, this is definitely one where, the old adage of you've got to look across the board and make sure that everybody's being treated, in a similar manner, and that, customer complaints are triggering the same kinds of discipline are important, because, the finely laid argument that Jolie set up for you would fall apart if, you had somebody who, was making non-religious comments and offending the customers, and nothing was being done about that. I mean, it's the most obvious example.
Exactly, exactly. So there's a couple more questions in the question and answer box. We do have a few more minutes. So the next question reads, must we record, and it says disposition, but I'll just read it verbatim. Must we record and disposition all applicants to our job postings and save their applications / resume in our records?
Yeah, I mean, there's another good one. So, if you are subject, if you're a government contractor and you're subject to OFCCP requirements, you're in one bucket. And I believe that the answer to that is a hard yes. If you're not a government contractor, you're still subject to, federal employment discrimination, laws, presumably, if you're big enough. I can't necessarily comment on state law equivalents, but if you're big enough where you're subject to federal anti-discrimination laws, yeah, you're looking at, I believe, and don't quote me on this one because I didn't look it up in advance. Who would have thought people cared about record keeping? But I think it's a 1 year on job applications. And the reason why you want to hang on to that, at least for, some period of time, is because of all of the different failure to hire claims that are potentially out there. If you have somebody who says, I didn't get the job because of criminal background, or I didn't get the job because, of a different kind of, different protected reason, and you're not saving the job applications, you could be in a tougher position if you're trying to say that they didn't get the position because somebody who was more qualified than they were applied, or, in the good old days, you just point to a stack of papers about yay high and say, oh, I think that application was somewhere near the bottom. Prove me wrong. And it was a pretty good defense to get you out of, failure to hire claims. So, keeping those records and maintaining those records, in many cases will help protect you. But, because, most of these types of employment discrimination cases are, under like a 300-day, statute of limitations, you may not have to hang on to them forever. But you should look at the record keeping issue from the perspective of, well, what if somebody says, I didn't get the job because of an unlawful reason? What am I going to be able to do to protect against that? If you don't have the records, it'll be a fun case. We'll take it. We'll have fun with it, and we'll see what we can do for you, right? Never say never. I'll fight for anything. But it would be easier if there was something that would help document what happened.
Right. And, another thing, so this is sort of a side note to think about too, is the laws of various states, and Illinois is one such example. The laws are developing with the changing world and the increasing technology and more robust technology that employers are using to interview and onboard applicants. So you want to be mindful of those types of laws. Like, for example, in Illinois, there's the Artificial Intelligence Act, which which really prohibits, which talks about the parameters that employers need to follow if they're using a video for interviewing employees. Like, do you keep the record of the video interview? Can you keep the record of the video interview? So there's some other AI laws and technology-based laws to keep in mind for purposes of dealing with applicants.
Yeah. The AI issue, to the extent you're rolling that out, you want to look at that carefully, because, I don't want to besmirch anybody's technology, but, these questions of bias and things are definitely out there. Illinois has a pretty aggressive law on it. Other states are looking at it. in terms of needing to be able to explain the metrics that are being applied by, the AI system, and, the potential for, bias having been interjected into, the system. And, my favorite anecdote was, apparently there was a system out there that if your name was Brandon, you were much more likely to get the job than anybody else, because there's some flaw that was in there. And, and then you imagine you're walking down the hallway, hey, Brandon, hey, Brandon, hey, Brandon. And then you get sued and you don't have the records and you don't know why. It's good times.
Yeah.
We got 5 minutes left. What else we got?
So there is one more question in the question and answer box, but it deals with Pennsylvania law. So, yeah, so we'll probably have to answer this if possible on the federal level. And we would encourage you to consult with a Pennsylvania attorney, or, we do practice nationwide as well. So
let's go. What's the question?
All right. You're right, Pete. Okay. If an employee is salaried, are they required to take PTO for a few hours taken on a given workday?
If they're salaried and they take off time,
Are they required to take PTO for a few hours taken on a given day?
I don't know the specifics of Pennsylvania, but generally speaking, the PTO policy and the enforcement of the PTO policies are left to the discretion of the employers. And so, you can have rules about minimum usage, minimum, time used. And, for salaried employees, it's generally, trying to avoid running into partial day deductions and things that would blow your salaried exemption on the federal level. But, certainly the U.S. Department of Labor isn't, going to get into the weeds on how you apply your PTO policy on top of that. And, generally speaking, if you can deduct PTO, you kind of want to deduct the PTO because it's an accrued benefit. And if you have an employee who's suddenly out for a long time and you've left those benefits on the table, it can be more difficult if you want them to come back. You think they should be coming back. They don't seem to be coming back, but then they've got a bunch of extra PTO time out there. It can make it a little bit harder to make a disciplinary decision. I don't know the rule in Pennsylvania on whether you have to pay PTO out upon termination. Illinois, you would. So you would want to, get that PTO off the books, because otherwise they're going to take the time off, quit, and then get paid, and get paid again for it. I don't know. Am I missing something? Because we've been at this for an hour, so I may be getting kind of loopy here, Jolie. I don't know.
No, I think you covered it. I think PTO laws, like you said, the laws really don't govern how employers manage their PTO hours. I mean, yes, there are state-specific examples, like California, I'm sure has state-specific, at the local level too in California. There's definitely specific laws that would control PTO and how that's allocated and how it's used. Like I know that in California, for example, it prohibits carryover laws. It prohibits non-carryover laws. So, you'd have to look at Pennsylvania to see if that is similar and if there's similar laws under Pennsylvania law, so that you can stay abreast of what to do in that situation.
Yeah, but the main thing to look for under the state law and to ask, a local lawyer about is, do you have to pay upon termination? Because if you do, you don't want to, somebody's working, half the time that they're supposed to, and you're leaving the PTO on the books, and then you get rid of them. And then you find out that they've got 300 days of PTO that you have to pay out. That is not a fun conversation to have. They never worked, but they racked up all this PTO, and now you got to pay it. Oh, it's brutal. Mm-hmm. Brutal if you say when you have that kind of thing happen to you. So,
And these are good things to make sure that you put in the employee handbook, right? Like
Yeah.
you should have, excuse me, have all of this laid out in the employee handbook first.
Absolutely. And, catering your employee handbook to the various states in which you do business makes a big difference too, because each state is very different, especially when it comes to wage and hour laws and PTO laws.